Hey, I'm Steve Loomis with Walking That Mile. So, the preliminary injunction has been put in place. This was April 27th, so 2 weeks ago or so now. Preliminary injunction in the lawsuit of cornpop, also known as Nicholas Blanchard, against the Augusta Maine School Board for violating his First Amendment rights. And there's a 34-page, the preliminary injunction is spelled out in 34 pages. It's pretty interesting to read. There's a lot of background on what Nick went through over the last year or so. A little bit less than a year. The first time that I saw him get shut down, I think, was in January of 2025. So he and I happened to catch, I believe I caught him on Fox News right about then, and I did my first video on the Augusta Maine School Board and the disaster that they are back in May. I published it May 2nd, 2025. Probably took me a couple weeks at that point to put that video together. But I have 17 videos on this specific topic, on the Augusta Maine School Board and what a disaster they are as far as violating people's First Amendment rights when they are up in front of the board doing public comment. So he got the preliminary injunction. What I want to read is just the last little bit of it. Again, it's 34 pages long. But the conclusion, so for the foregoing reasons, the court grants in part and denies in part. This is pretty interesting. Mr. Blanchard's motion for a preliminary injunction. The court grants the motion as the Rule E ban of gossip, abusive language, and vulgar language. So Rule E is in BEDH. It's the policy that Muffy, the school board chair, tried to enforce against Nick each and every time that he went before the board. So E portion of the BEDH policy was gossip, abusive language, vulgar language. And the preliminary injunction grants the injunction against that. It also grants the motion against the Rule H and in its entirety, and grants the motion to Rule J solely as it relates to the chair enforcing the portions of the policy BEDH herein enjoined. Now, whatever, this is a lot of legal jargon, but the court denies part of the motion. The one part of the motion is Rule E. Rule E bans defamatory comments. Okay? That's the only part that the judge, the Honorable Stacy D. Newman, she only grants or denies motion against defamatory comments because that's in the policy. Well, defamatory comments, defamation is illegal. I mean, it's a tort. It's civil. It's a civil violation. It's not a criminal violation. It's to be guilty of defamation is, it's illegal. So she cannot grant a motion against speaking defamatory comments in front of the board because it's illegal to defame somebody. Now, there's no possible way that the board should be able to claim defamatory comments when they're shutting somebody down, because how do they know? How do they have the resources or the knowledge to possibly know that what you're saying in front of them is in fact defamatory. Defamatory has a number of criteria to it. So elements requiring defamatory. First of all, the statement must be false. It must be a false statement that you are claiming is fact. Okay? Truth, right there, you start with that. It's a false statement that you claim is, you're not alleging or like speculating, you're claiming something is true when it's actually false. Okay? Truth, if you're saying something that's true, truth is an absolute defense. So then shut down right there. Okay? Number 2, the statement is defamatory in nature. It tends to harm the reputation, expose to scorn, that kind of thing. So it is defamatory in nature. Okay? It is, number 3, publication to a third party. So it has to be transmitted somehow to somebody, to a third party. Fault, at least negligence, but higher, typically, is actual malice. Like you did it to hurt that person, to try and hurt that person's reputation. Okay? And then there has to actually be harm. Damages. Okay? Though some statements are per se defamatory, damages are presumed. You can fight for damages if you are in fact harmed. So if somebody claims you did something that you didn't do, you're guilty of something that you're not guilty of, and you lost a job or you lost a book deal or whatever, that's harm. That's defamatory. So how can a board member or a board chair in real time, as you're speaking, as somebody's up there speaking, determine all of this stuff, that it's actually defamatory? They can't, but a judge can't deny that part of the motion because defamatory conduct is, against, it's a tort. It's illegal. So that's the only part that she denied. That's the only part that the board won of the whole thing. Okay? So now, this is called a preliminary injunction. So this is before the actual case could go to trial, as far as, because what happens next, then you seek damages, right? So they've already got the injunction in place. And the other thing is that there can be a bond requirement, what's called a bond requirement. So if Nick was likely, if there was likely to be some sort of loss of money because of this preliminary injunction, this doesn't usually happen in a case like that. I guess they have to talk about it, but if there was a preliminary injunction where it stopped me, I'm kind of shooting from the hip here, but like stopped me from using a recipe because somebody claims that was their recipe, and I didn't have the rights to use it. But that recipe is what I used to make food that I sold in my business, and that's my only income. And so now you've stopped me from using this recipe because of the preliminary injunction that was granted, and now I'm losing all this income. And so they can require a bond from the other party to put in place to hold in case that person or that party loses, to try and make me financially whole if I win the lawsuit, okay? So they say there's absolutely no reason for a bond, against Nick in this case. Mr. Blanchard asked the court to waive the security requirement, the security bond, on the grounds that the compliance with the injunction will not cause the defendants to suffer monetary or no monetary harm. Makes sense. If going forward, it turns out that BEDH, this policy, is going to be granted, yes, everything is above board. It says, given that this case involves the protection of the First Amendment rights and defendants have not identified any compensable harm that would suffer if policy BEDH were wrongfully enjoined, the court exercises its discretion to require no security interest. So that's the only other thing that they talk about here. Now, what Nick posted, which is quite interesting, is then Nick posted, yes, I also want audio. Hopefully this is loud enough. So this is Muffy, the board chair, talking about the fact that the preliminary injunction was granted. Listen to how she talks, and she talks that they have their lawyers writing up policy and whatever, and they have a letter that they wanted to share. Now, I'll tell you what, their lawyers have been horseshit this entire time. I don't know how much the city of Augusta has been paying for these attorneys. They brought in attorneys. I've done videos on all of this stuff. They brought in an attorney to do this business meeting where the attorney is trying to answer questions. He didn't know anything. He really didn't know anything. It was embarrassing. I was embarrassed for him. I was absolutely embarrassed for him. And then when they got some heat, they actually brought an attorney to their school board meetings for a while too, to bounce off ideas when people were stepping up, when Nick was stepping up, when Mr. Bodner was stepping up and pushing the envelope a little bit. They then had to go to this attorney who was there in real time and ask, and of course he backed down and allowed them to say things that Muffy would not allow usually. But so here is her. She's still trying to save face. This is going to come and bite her in the butt because they are going to lose they're going to lose hundreds of thousands of dollars on this case. This is just a preliminary injunction. So that judge just went through the policy. Was the policy right or wrong? And you heard that it was wrong in everything except defamatory comments, which are illegal anyway, basically illegal anyway. They're a little bit more nuanced than just they're illegal. But so this judge didn't go into Muffy's conduct in each and every one of these meetings where she shut Nick down. They didn't go into that yet. That's coming. But listen to her here.
This lawsuit that the Friday before vacation, you and I went to Bangor for what is called the preliminary injunction that Nicholas Blanchard had requested that there be an interim injunction to give him some immediate rights that he felt he didn't have at the time. And this is the statement that our lawyer crafted. As a result, they were in the decision of the judge. It was found that some of our policy, the words were too vague to enforce. The words that we could not enforce in our current policy were the words gossip, that was too squishy. The words abusive, the words vulgar were not definable in her opinion.
That's not true. They're protected speech. So let's get this clear. Those things are protected speech. You can use those words it's stupid that they were in your policy.
However, she did say that defamatory would remain in our, defamatory comments would remain, could remain in the policy. It also included that the word that referred to personnel in our policy, it had personal matters rather than the word personnel, and that the word personnel matters negated that whole line.
Yeah, it negates it because the policy specifically says that when you are up there to make your public comment, you are there to comment on school board, school issues, not personal, private issues of people. So it already says that in that's what the whole policy is about. So, yes, you put personal matters in there. That whole line does get struck because that's not what the policy is about.
And in the policy you have tonight, our attorneys have crafted another sentence that refers to statute in order to protect our employees. The other decision was that the chair of the committee could not enforce the rule regarding the words gossip, abusive, or vulgar. This was just a piece of the lawsuit. This was just a part of the temporary injunction. So Melissa Huey has crafted the policy, and her associates have crafted the policy that presented to you tonight. And with that, I'll pass it to you. And I was going to read the statement that she said. This is the public statement that she said we could share publicly. The Augusta School Department is committed to complying with federal and state laws, including its commitment to the First Amendment rights of all individuals who appear before it.
I'm going to stop you there because you have had a year to adjust this policy. You have had your attorneys look over it many times. You have had other people comment in front of the board. One woman in particular, I don't remember her name. She is in a video that I will link up here. She very specifically says that she is an attorney and she knows these laws way better than anybody. Clearly, that the city of Augusta, the Augusta School Board chooses to work with as far as for their legal matters. And so no, you don't. You clearly don't want to abide by federal law. Not at all. You were hoping to be able to bully Nick Blanchard, and you did. You bullied him for months, and you shut him down many, many times. And he didn't make a stink every time. He asked some questions, but when you pushed, you sent him, and he stopped. And now he's going to win this, and he's going to win, I'm hoping, hundreds of thousands of dollars. And I'll say this too. I'm from Minnesota. I saw Nick Blanchard's case a year ago on Fox News. That's how I got involved in this, which pissed me off so much that I started doing these videos. And I started doing these videos, and each one of my YouTube videos, I emailed to each member of the Augusta Maine School Board. I sent a link to each of my new videos to each member of the Augusta Maine School Board. So when you look up my videos, I will have lots of, well, maybe you can't even see the dislikes. I will have some significant dislikes in these videos, which is different from my other videos. And I would guess that it's people that I specifically sought out to show them these videos. And I'm sure they didn't like what I had to say. But I tried, and I've even tried a couple of times in some of my videos saying, I think a lawsuit's the only way that this is going to be resolved. That this board chair specifically, is not going to stop until they lose hundreds of thousands of dollars. She isn't embarrassed enough yet, even with this preliminary injunction. She is going to, in just a second, she's going to say, I did nothing wrong, or at least the judge hasn't said that I, as the chair, my enforcing the policy wasn't wrong. It's the policy that was wrong. I tried to help too. I thought maybe that with everybody coming at them saying that what they were doing was illegal, that they would stop. Nope. And these attorneys were right there guiding them this whole time. So they deserve to lose a lot of money.
Simultaneously, we believe public school board meetings should be places of decorum and civility. We plan to revise our policy as necessary to ensure that it stands up to our commitment to the First Amendment, while continuing to provide protection to the privacy of our students and employees that the law also requires. It is important to note that the court's opinion was based on the language of our public comment policy, not on the specific treatment of Mr. Blanchard. We do not read the court's opinion as giving Mr. Blanchard or anyone else free rein to disrupt the business of the board, and we are committed to conducting our meetings in a way that exemplifies civility and respect for all.
How ridiculous, right? How stupid. That's the attorneys using their speak, trying to smoke and mirrors. Yeah, of course. Nobody has free rein. This whole time, every time that Nick got shut down, he wasn't doing anything wrong. He wasn't being vulgar at all. I don't think he swore once. Some other people got up in front and swore because they knew that they could. I don't think that he swore once. So, no. Nobody thinks that they all of a sudden have free rein. They just want to be able to speak. They just want to be able to make their comments, their public comments, without getting shut down. And it's 100% viewpoint discrimination. Miss Muffy, she, Martha Witham is her name. She shut down Nick or anybody who sided on the conservative side, and she let other people, she gave them free rein. And she was even confronted by her own board members, James Orr, Katie McCormick, specifically, because those are the only two that had any guts on this board at all. She was confronted by them in public meetings multiple times and saying, like, you can just let Nick speak and you shouldn't let this other woman, Jenny something, say all the things that she was saying because it had nothing to do with the board of the school. She was bitching and moaning about Nick and some other people commenting online about some things, and she was doing that in front of the school board and wasting their time. And she was Miss Witham was confronted by Katie McCormick and James Orr numerous times, and she overruled them and let these other people speak. So nobody thought that they had free rein. Nobody thinks that they have free rein now. Nick Blanchard just wanted the ability to speak his mind in front of the school board like he should have been able to. And it has gotten to this point because of people like Martha Witham.
So they did not find that that the chair had stepped on his toes. It was the policy that was the problem.
Not yet. That part's coming. I can't wait to read the opinion when if this actually goes to a trial and they don't settle for hundreds of thousands of dollars. It should be hundreds of thousands of dollars that they would settle for. $1 million, honestly. It's a year of this. This wasn't one time or two times. This was all year long that Nick and people like Nick were being shut down. It could easily be $1 million plus. So that would be the settlement. Now, if they settled, that'd be good because they would hopefully make a lot of money that they deserved. And there would be some pain for the school district that these are the people that you put on the school board, and this is how financially, fiscal responsibility. They just had to cut a whole bunch from the budget this year, and you shut people down because you don't like what they say, and you're going to lose our school district $1 million potentially. Maybe that'll wake people up.